Hi, students. Today we're going to talk about elements and facts. We're also going to talk about factors. You should have a copy of this, the PowerPoint slide deck already loaded up on Lexis and Canvas. So let's go ahead and get started. So one of the things that lawyers have to do is make predictions. That's why it's so important for the law to be predictable, because oftentimes we have clients come into our office and ask us many, many questions about, what are my chances, what's going to happen. And so in order to answer those questions, we have to make predictions. Now, the way legal research and writing is set up is that we always start with objective analysis. Now, I know many of you came to law school thinking the first thing you were going to get to do was make these brilliant legal arguments and persuade. We don't actually focus on persuasion until Legal 2. Let me tell you why. Before you can be effective at making a persuasive argument, you have to know how to look at the law objectively. If you look at the law with tunnel vision and just try to cherry pick those cases that help you while ignoring the cases that hurt you, you're not going to be effective. So we're going to instead focus on looking at the law objectively, looking at the rules and the issues objectively, and looking at not only arguments, but counter arguments as well. So when we talk about legal analysis, in its most basic sense, it's all about answering questions from different parties, whether that be judges or clients, law professors or other lawyers, or bar examiners. When a client comes to your office and asks you a question, the question will probably be very broad. Can I sue? Do I have a case? What's going to happen? Will I be found guilty? Were my rights violated? Your job is to take that very broad question and to figure out what the legal issue is in dispute. So let me give you an example. Client comes to your case and says, "Oh, I'm so upset. I was going to a store and the loss prevention officer accused me of stealing and I was humiliated and it was the worst experience of my entire life and I want them to pay." And they're going on and on about the emotional ordeal involved. And I want you to hear them and their pain because that's going to help you decide how to advocate for them. But I also need you to be thinking like a lawyer. So in the back of your mind, you should be thinking, "Oh, that sounds like a tort. It's not a criminal action, sounds like a civil action. Maybe it's the tort of false imprisonment. In order to determine if someone can be found liable for false imprisonment, we need to see these elements." And you go from there. And that is going to help you take that broad question of, "Hey, do I have a case?" into the specific legal issue that you need to research and analyze in order to be successful. Let's start with the facts. Client comes to your office and lays down facts. What facts are most important to you? We've got essential, also known as determinative facts, explanatory facts, and coincidental facts. Let's break all of those down. Now, determinative facts, some people call them essential facts, some people call them outcome determinative facts. These are the most important. These are facts that are so essential and so important to the controversy that if I change that fact, I could potentially reach a different decision, right? So this happens oftentimes in hypotheticals. Your doctrinal professor gives you a hypothetical fact pattern and they change something. If they change something essential, then your analysis or your conclusion may change. So you want to know, what are the essential facts? What facts are essential to the controversy? Also known as determinative. And then we have explanatory facts. Explanatory facts are useful. These are facts that provide context to the person who is listening or reading about what happened. It helps the story make sense. So they explain things, kind of make sure things flow and are put together. And then we have coincidental facts. Sometimes these are just red herrings. These are things that just happened. They have no real relevance or usefulness. So, for example, unless you're talking about an emotional distress claim, the fact that your client said they were humiliated and devastated, that's not necessarily relevant to the fact of whether or not you can sue for false imprisonment. Coincidental facts would also include, oh, I was mugged outside of Baskin Robbins, and the person had on a red jacket. Well, does it matter that the mugging took place outside of Baskin Robbins? Maybe, maybe not. But if it doesn't matter, then that's just a coincidental fact. You may want to exclude it. So think about trimming out those coincidental facts from your memos, briefs, and examinations, and instead focusing on your determinative facts and your explanatory facts. So which facts matter the most? Determinative facts, also known as essential. Whatever facts that will help determine the outcome in a case. Essential facts and elements in a case are dependent on each other. They really are. It's like a marriage. So if you have your essential facts and you've got your elements, that's going to help you figure out, well, what is the issue? So knowing the essential facts depends on knowing the elements and vice versa. So I mentioned the word elements. What do I mean by elements? When I think of elements, I want you to think of the word requirements. Okay. Every cause of action or claim has distinct requirements. Some are based on enacted law, like statutes. Some are based on common law, also known as judge-made law. Your job is to try to break down the requirements of the law and analyze each separately. So in order to figure out what the elements are, you need to break down the law into its essential components. So let's imagine you have a statute. You want to break each component of the statute into smaller parts. Outlining a statute and identifying the elements is going to help you with your legal writing and analysis. Let me give you an example. Let's say I'm a prosecutor and I have a driving while intoxicated case. In order to be found guilty of driving while intoxicated, you have to be operating a motor vehicle in a public place while intoxicated. Okay. So in order to find a defendant guilty, I have to prove all of that beyond a reasonable doubt. It's not enough for me to just say, oh, well, he was drunk. I have to prove that the defendant was, one, operating, two, a motor vehicle, in what? Three, a public place, while four, intoxicated. So I have four different elements and I have to prove all of those. And because elements are requirements, if I'm missing one of those elements, it's game over for my case. I cannot convict the defendant. I'm unable to prove my burden beyond a reasonable doubt. Similarly, anytime you have a cause of action and you have elements, so it's an elemental test, if you're missing an element, if you can't prove one, it is like the game Monopoly. Go to jail, go directly to jail, don't pass, go. It's game over because you can't have a cause of action if you're missing one because elements are required. Let's think about a statute and a law that I talk about frequently in orientation, and that is necessity. We know that necessity, here's our definition, includes an injury or immediate threat of injury to human life and the urgency of the circumstances made it necessary to drive. So that's that necessity defense. Which makes more sense for you to analyze it? That like that, where we just have the statute, or like this, where we've broken it down? An injury or threat of injury to human life, and the urgency of the circumstances made it necessary to drive. By breaking it down, it's a good reminder to you as a law student, as an attorney, that you've got to have both of these things in order to have that defense be available to you. Okay, so you don't want to just read the law in some big paragraph, but you want to be able to break it down to its essential components. You can also do an element list when you're talking about common law elements. So one example would be IIED, or intentional infliction of emotional distress. Now we know that the tort of intentional infliction of emotional distress has four elements, so you will learn about that later in tort class. The defendant must, one, act intentionally or recklessly. Two, the conduct must be extreme and outrageous. Three, the conduct must be the cause, so there's a causation requirement. And four, of severe emotional distress. So breaking it down in this way lets you know, it's a good reminder that I have to have all of these components. Here's another example. This is from an Oregon statute. And it's interesting because it's written in the disjunctive. A person commits the crime of unlawful use of an electrical stun gun, tear gas, or mace in the second degree if the person recklessly discharges an electrical stun gun, tear gas, weapon, mace, tear gas, pepper mace, or any similar deleterious agent against another person. I would break down that statute like this. Do you see how this may make it easier to analyze? Easier to make sure that each and every component has been satisfied. In fact, when I was a prosecutor, it'd be very common for me as part of my closing argument to have an element checklist. And I would check it off in front of the jury. I promise you that I was going to prove this and I was going to prove that. And I would just check off all the things that I was required to prove beyond a reasonable doubt because it helped the jury and it helped me make sure that I focus on proving everything in my case. So an element checklist is something I want you to get used to doing in your classes. It's going to help you define the legal issues. So when the question comes up, what is the issue in dispute? That element checklist is actually going to help you. We're going to do an exercise, a few exercises in our next Zoom meeting class that's going to help us do an element checklist. Another benefit besides define the issue is it outlines the law for your written analysis. So when it comes to getting ready to draft that memo or that brief, it's important to, in the beginning, tell the reader what's the law. What are the elements that have to be proven in order to have a prima facie case? And then you can also help, the element list can be used whether you're dealing with a statutory issue or a common law issue. So elements are required. That is very different from something else called factors. When you think of factors, think flexible considerations, okay? If there are 5 factors that the court considers and I only have 1, it may not be game over. 1 may be sufficient because factors are not requirements. Factors are flexible considerations. A court may base its decision based on just 1 factor being present or multiple factors. A great example is the best interest of the child statute. So here's an example of a statute with factors. And I couldn't even write it all because there's so many different factors. But here it says, as used in this act, best interest of the child means love and affections and other emotional ties existing between the parties involved in the child, permanence as a family unit of the existing proposed custodial home, the moral fitness of the parties, the mental and physical health of the parties, the home, school, and community record of the child, the reasonable preference of the child, the willingness and ability of the parents to facilitate and encourage a close and continuing parent-child relationship between the child and the other parent. So what if a parent has F, G, and J, and that's it? Well, if they're not requirements, these are just things, flexible considerations the court takes into account when determining what in fact is in the best interest of the child. So remember this, elements are requirements to establish a cause of action exists. If a cause of action is missing an element, that cause of action will fail. Factors, on the other hand, are flexible considerations a court may consider. So if there is one element that has 5 factors that can be satisfied and only 1 is present, they may still prevail. Here's another example of intentional infliction of emotional distress. So looking back at this common law rule, the tort of IAD has 4 elements, and I've already listed them. Well, let's say the element in dispute for our particular project is number 2. The defendant's conduct must be extreme and outrageous. Well, let's say the factors that the court looks at when determining whether or not that second element of extreme and outrageous conduct is satisfied includes the existence of a fiduciary duty, whether the person was in a position of power, whether the plaintiff was particularly vulnerable. So let me give you an example. Let's say a stranger on the street wants to claim that I caused them intentional infliction of emotional distress. And what they point to as my extreme and outrageous conduct towards them was I said that they were not very smart. Well, in looking at the factors for extreme and outrageous, if there's no existence of fiduciary duty, if I'm not in a position of power, if I'm not aware that the plaintiff was particularly vulnerable, then they're probably not going to be successful in establishing that element. And if they can't establish the element, they're not going to be able to have the cause of action for IAD. Let's say I got drunk one day, not going to happen, and said to a student, "You're not very smart." Well, now we're talking about something different, because if I were to say something ugly like that to a student, I'm already in a position of power by being their professor. So there's a totally different impact of me saying that to them than it would be a stranger in the street. Now, does that mean automatically that they're going to prevail in their charge? No, but it is a factor that is certainly going to weigh in their favor. Now, how does this relate to legal writing? Because remember, our big end product is going to be the memo or the memorandum. In terms of dealing with elements and factors, they belong in the very beginning of your memo in your roadmap paragraphs. Roadmap paragraphs are those first introductory paragraphs. They include the overview paragraph and the thesis paragraph. An opportunity for you, before you get into all the nitty gritty, for you to summarize the law. So elements and factors would belong in your roadmap paragraphs. So elements required, factors, flexible considerations. What if I'm doing research and I have a bunch of cases? I've got 5, 10 cases that I'm looking for. How do I figure out what the factors are then? Well, a couple things you want to look for. Sometimes you're going to be very fortunate and a case will say, the factors this court has considered in the past include, and they'll just list them for you. Sometimes you're going to have to make an inference. If you're in the position where no case has just done the work for you, then you want to make sure you read the case carefully. Is it out of the same jurisdiction? If you're talking about a different jurisdiction, if you're in Texas and you're looking at California, you're way off, right? Is it from a higher court? If it's just a trial court that said it, it's not nearly as important as if the Texas Supreme Court said it. Is it dealing with a similar issue? Okay. And if all of that is present, then you want to figure out which facts seem to be emphasized by the court. What was concerning to the court? What was important to the court? Those are those will ultimately become your factors if they're not already identified for you. So you would then want to group all of those facts together to figure out what the factors are. Sometimes it's going to be explicit or it may be implicit. So in terms of the elements plus the facts are going to lead you to your legal issue. We're going to develop that whole concept a little bit more in our Zoom meeting. All right, so that's the end of this mini lecture. There is a very brief completion quiz on Lexis, and I ask you to complete it. As always, if you have any questions, please let me know, and I hope you have a wonderful rest of your day.